Welcome. Welcome to A Taste of Justice. I'm Professor Angela Mae Kupinda. For informational purposes, I'm a professor of law at Mississippi College School of Law. I've been teaching in law and business schools for about 30 years now. I do enjoy teaching so much. This is maybe my final recording for this spring semester. I'm going to tell you later about some exciting things we're about to, not that this is not exciting, it is. I hope you believe it is, I do. But I'm going to tell you about some things we will be doing in my classes. And so, but in the future, I do plan to be back. So you make sure you subscribe and sign up for notifications so you will not miss it when I record another one. This clip is a very exciting one for a couple of different reasons. For one, it's about student speech, which is one of my favorite topics. And it is about a recent case that the Supreme Court decided just last year. Now, there's another reason it's so important to me. Last year, and again this year, my students researched and prepared position statements, their positions on current First Amendment conflicts. We had an amazing time hearing what mattered to them, hearing them defend their position and discuss positions contrary to their own. Now, one of the cases that the students presented on is the case that we're going to talk about right now, the case the Supreme Court recently decided, and I've given you the title of the case below in the text box. You've got to go and read that full opinion. It is indeed something else. And even more than that, I think my students got it, well, I won't say they got it right. I will say that in general, their views were in line with the views of the court. Now, let me tell you about this case. I have 5 points I want to make, okay? Point one, last year, the court considered a case called Mahanoy versus BL. It was decided in 2021. If you type that in Google, you should be able to come up with maybe a video of the oral argument and also the court's full opinion and Justice Thomas's dissent, which you may also find quite interesting. Now, this case, this young woman was a cheerleader at a school. She was on the, I believe, like varsity team. I was not a cheerleader, so I don't follow all the terminology. And she wanted to be on the high school squad, which she tried out for, but she did not make it. And the school told her that she would have to be on the varsity team, I take it with the younger girls, for another year. When she heard this, she was very upset. She was very disappointed and very angry. She had a Snapchat account with 200 or more followers or friends. And so she took to Snapchat talking about how angry she was with the school. But she didn't just say, I'm angry, I didn't make the team. She used some profanity. She used the F word. You know what I'm talking about. She used the F word, saying F the school and F cheerleading and a lot of other things on her Snapchat. Now, when she did this, she was not on the school campus when she when she made these statements on her Snapchat account. But some of the girls from the cheerleading team were her friends on Snapchat and got quite upset about what all she said. So they went to the school about it, and ultimately the school disciplined BL and told her she would be suspended from cheerleading completely for a year. She and her parents were not happy about that. They said that BL was exercising her freedom of speech, and so therefore they filed suit. Wow. Now, what do you think about that? Do you think the student should win this case? Or do you think the school was correct in disciplining her? Now, that's point one. I want to tell you about that. Now, point two. In an earlier clip, and I've given you the link to the clip below, I talked about some other schoolhouse cases. And one case that I talked about is called Tinker. And Tinker, the court ruled in it in 1969. What happened in Tinker, I know I'm going back to Tinker because Tinker may be relevant to what the court ruled in BL's case, okay? All right, so in Tinker, the court said we had some students who were protesting the Vietnam War. To protest the war, the students wore Black armbands. They had a silent protest. They wore Black armbands to school. And the students were disciplined as a result of that. The court ruled in that case, the court said several things. First of all, the court said that schools and teachers do not leave all of their First Amendment rights outside the schoolhouse gates once they enter the school. For teachers, it is called academic freedom. And as a teacher, I do value my academic freedom. Now, the court also said that for students, the speech rights that they have at school are not to the same degree as the speech rights that adults have generally. And the court articulated a test. The court said that to punish students, such as in Tinker for the armband protest, the school would have to show that the speech materially and substantially interfered with the school's mission and order, okay? And I typed out that rule for you in the text box below. So with the armband protest, the court said it did not materially and substantially interfere with the school's educational mission or with order at the school. So therefore, the student's speech was protected and they could not be disciplined in the Tinker case. Now, and below I have a longer clip about that case and other cases involving student speech. So my third point, BL's case, as you've listened, was different from the case in Tinker. In Tinker, the speech, the wearing of the armband, the speech happened on campus. But in BL's case, she wrote the Snapchat, the chat, when she was off campus. BL was on social media, although it arguably carried over to the campus. BL's speech was verbal. She said certain things, and she also did some hand signs as related to the F word. Now, in Tinker, The speech was the silent wearing of an armband. It was a message, but it was a silent message, a silent protest. In BL's case, the speech was about cheerleading and making a cheerleading team. But in Tinker, it was about political discourse and a protest as to the Vietnam War. Tinker also occurred during the time there was a mandatory draft, and of course, young men were being drafted into the military, some of them perhaps right out of high school. So, point four. Point four is I want to tell you about my students' position statements. You're probably saying, why don't she stop talking about that? It is so important. We're going to have such a great time. So last semester, a number of my students wrote position statements related to this case. And in their position statements, they argued a number of different things. Some students said that her speech should be protected. Some students said that almost all student speech should be protected. Some said it should be protected because it was social media and she was not on campus. Others said there has to be some limits because even on social media, there may be cyber stalking, there may be bullying that the school has a legitimate interest to punish. Okay, so I've given you in the text box below some links where you can go and you can hear more about what my students were saying about this case. And then you can determine whether you think they ruled according to the court or whether their arguments perhaps were even better than those of the court. Okay, now back to BL and Tinker. So the court, some people thought that in the BL case that the court would overrule Tinker and say that Tinker is no longer good law. But the court didn't do that. The court didn't really lay out a test in terms of student speech affecting the school setting to some degree, but the speech is made away from campus or on social media. The court says, we're not going to get into the specifics of a rule right now. The court just made some guiding principles, and I want to talk about a couple of them. The court says that, of course, the school has authority when the child is at school. In a way, the school is acting as the parent. But then when the child leaves the school, the parent should have primary authority over the child. The court says, of course, sometimes this authority may overlap. The court said that, of course, the school may want to discipline certain speech, even if it's on social media, if it's affecting the school setting, school discipline, perhaps with things like cyber stalking or bullying or what have you. But it says that in general, though, with social media and with the student being within the supervision of the parent, the school would have a fairly high showing to show that it ought to discipline speech. You see, the court talked in generalities without a specific test, but in conclusion, the court said that BL's speech was protected speech, and therefore her suspension from cheerleading was in violation of her First Amendment rights. My students generally came pretty close to what the court held. but I've given you the links below so you can go back and listen and read about their position statements and determine for yourself what you think. So as I said, this semester, we're about to move into the next phase in a few weeks where my students will take an extended take-home exam to analyze First Amendment issues. After that, they're going to research and draft their position statements on current First Amendment conflicts. They will present them in class, and well, we will probably have some disagreement and some respectful disagreement as we debate their positions and whether their classmates will comment as to whether they agree with the analysis that the students give or not on these current problems. Learning is a path to enlightenment, and enlightenment to freedom, and freedom to justice, or at least a taste of it. I will see you again, I hope, as I post on another course in the future. I do enjoy working with my students, and I do enjoy sharing about the Constitution with you. So probably not any more clips within the next few weeks or a month or so, but I do hope to see you again. So you take care until we meet again. And for now, you subscribe and sign up for notifications so you will not miss a thing. Thank you. Bye-bye.